To welcome everybody to the Midwifery Advisory Council meeting. I'm Carrie Sparavon and I chair this committee. I'd like to remind everybody to please put your cell phones on vibrate or turn them off. If you'd like to provide public comment, please fill out a speaker slip in the back, although it's not mandatory, and give it to Miss Sewell. Where is she? There she is in the back, Anna Marie. MAC members, a reminder that during today's meeting and all future MAC meetings, any items requiring a vote will be done by roll call vote. This means that once a motion is made and seconded, Ms. Alameda will call each of our names individually to request our vote, at which time you can vote in favor, against, or abstain. Any questions? Okay. I'd like to now call this meeting to order. Ms. Alameda, would you please call the roll?
Sure, thank you. Dr. Adams? Absent. Ms. Dugan?
Present.
Ms. Holzer? Ms. Perez?
Present.
Mr. Jaroslawski?
Present.
And Ms. Sparavon.
Present.
We have a quorum.
Agenda item 2 is public comment on items not on the agenda. Note that the council may not discuss or take any action on any matter raised during this public comment section that's not included on this agenda, except to decide whether to place the matter on the agenda of a future meeting. I'd like to also recognize Patrick Lee, who is Assistant Deputy Director in the Office of Board and Bureau Services for the Department of Consumer Affairs. Welcome. Thank you for being here. Is there any public comment on items not on the agenda today? All right, seeing none, we'll move on to approval of the August 17th, 2017 Midwifery Advisory Council meeting minutes. Every member on the Midwifery Advisory Council received the minutes ahead of time and was asked to provide any comments they had on the minutes to Ms. Almeida. Are there any comments on the minutes that were not provided to Ms. Almeida? No, okay. So Ms. Almeida, would you please review what the couple of edits were?
Sure, thank you. On page 2, under agenda item 5, we're striking out the Los Rios Community College District and adding American River College. And then on page 3, under agenda item 6, about the third line down, we're striking Congress and adding college.
Right.
Those were the only 2 edits.
All right. So I need,
So moved. Motion to approve.
thank you, Barbara. Second. All right. Is there any public comment on the meeting minutes from our last meeting in August? Any council comments on those?
No.
Great. Let's go ahead and take a roll call vote then.
Okay, Ms. Dugan?
In favor.
Ms. Holzer? Favor. Ms. Perez?
Favor.
Mr. Jaroslawski? I'm always saying that wrong, sorry.
Agreed.
Ms. Sparavon?
Agree. All right. So item agenda 4 is my report. And I'm just going to take this opportunity to say a big thank you for the years that I've been able to serve on the Midwifery Advisory Council and the people that I've met and the hopefully improvements that we've made to the program during that time. I am not going to seek re-election to the Midwifery Advisory Council when my term is up in March. So I hope that there are lots of people that apply so that we have a good pool of applicants and can make good decisions on seating the next member. So that's kind of all I have to say. Are there any comments or questions from anybody?
I'm disappointed. I have enjoyed working with you, and I think you bring to the table an immense wealth of knowledge and breadth of scope of information. I want to thank you for your engagement. You're putting up with this. It's not so easy.
Thank you, Barbara. It's been really, really wonderful working with everybody that I've worked with here, and I will miss it, but I stopped practicing a year ago. active practice, and I'm looking forward to spending more time midwifing sheep. All right. Any other comments? All right, let's move up.
Thank you very much for your service, Carrie. It's very much appreciated.
Thank you. Thank you too, Barbara. I appreciate that. For those of you that don't know, I'm one of the original members of the Midwifery Advisory Council, and I've been serving since 2007, so it kind of seems time for some new blood. So encourage people that you know that you think would be good serving on the Midwifery Advisory Council to please apply. All right, let's move forward to Ms. Webb's presentation on the Begley-Keene, his name I can't ever remember, Open Meetings Act.
Members, thank you for letting me speak today and give this presentation. And I've been advised that the color is off. I guess there's a light bulb that isn't working. So you do have a paper copy. So for members of the audience, of course, it looked much better when I prepared it than what it looks like there. There are also, I think, a few paper copies available for audience members if you want. So we are doing this to provide some training for our council members and also to advise the members of the audience what the Open Meeting Act is all about. So first thing, any legal wonks in here? I've provided the code sections for your further information because obviously this is a truncated version of what the law actually covers. But the point of the Open Meeting Act is that public agencies must conduct their business openly so that the public can be informed and participate. And I think this is an important section directly out of the law that the people have established these public agencies. The people do not relinquish control of the public agencies, and you don't get to decide what information they get to know and what they don't get to know, is the point of this Open Meeting Act. They retain control over the entities they have created. So there's some underlying principles. First is there must be a meaningful opportunity for members of the public to participate and observe meetings. So meaningful means there must be informed advance notice of the fact that a meeting is going to occur and what it's going to be about. And it also means that there has to be actual access, including for members of the public with disabilities. Now, the fact that we have to give advance notice and make sure we have it in a proper place means that planning is involved. You can't, at a spur of a moment, plan a meeting because it would be efficient to do so and make doing the business easier. This rule makes it so that public participation in government outweighs efficiency. So a meeting is any congregation of a majority of the members of the state body at the same time and place to hear, discuss, or deliberate upon any item within the jurisdiction of that state body. Now you'll notice there's fine print because exceptions apply. A state body can also be broken down further into smaller groups, such as committees and task forces. And the Open Meeting Act still applies to those smaller groups unless it's a committee or task force that is made up of less than 3 people. And so occasionally you'll find that state bodies create 2-person task forces. And that is so discrete items can be addressed in a more efficient basis, but they always report back to the fuller body in a public meeting to air recommendations and have lively discussion that includes public members before a vote is taken on an item. So this act prevents a majority of the members of the state body outside of a noticed meeting, which is what we're having here today, from using direct communication, notice the fine print, unless it's a closed session meeting, which would be, I think, highly unusual for this particular state body to have. So I'm not going to go into that, but there are exceptions. So direct communication, you call someone up, you approach them, you talk to them as a group. A serial communication, this is where you start making phone calls, and through serial communications, the majority of the state body ends up discussing a matter that is within the jurisdiction of the MAC. Communication through intermediaries, so you can't use an assistant, a significant other, to do the same thing that you are prevented from doing yourself. And then also it prevents communication through social media to try to address matters that are within the jurisdiction of the state body. And again, to circle back around, it prohibits those communications when the purpose is to discuss, deliberate, or take action on any item of business which is within the subject matter of this MAC. Fine print, exceptions apply. So there are exceptions, or I provided examples of potential violations that you should be alert to so you can avoid them. So say you get together because you really want to clarify an issue that's within the council's jurisdiction. So you can sound informed and prepared and all be on the same page before the MAC meeting. You can't do that with your other MAC members. You can't contact each other to try to reach a compromise on a matter that may be sensitive or uncomfortable to do in a public forum. That's just part of the Open Meeting Act process. You got to do it in the public forum. Or engage in conversations that advance a resolution of an issue ahead of time. And similarly, any conversation on aspect of the deliberative process. You know, decisions are made on what to recommend to the medical board. You can't do that outside of this meeting when it's not noticed an open meeting with the majority of the members. And the point is that these discussions, if you do it outside of an open meeting, are taking place where the public cannot weigh in and provide important information and feedback that you need. You need to take into consideration the viewpoints of the public and the other midwives that you serve. So there are communications and get-togethers that are not violations. So all of you can talk to members of the public, not as a group where you're deliberating something before you, but you can talk to, as individuals, members of the public. But just a reminder, you can't purport to represent the MAC in those discussions unless you've been delegated that type of authority. You can talk as an individual person. You can talk to medical board staff to get clarification on any issue that we may be discussing at the meeting or anything else. But as a reminder, I put in here, staff can't say, well, I talked to Ms. Sparavon and she thinks X, Y, and Z. And you can create a serial communication in that way if staff is sharing viewpoints. The majority of the council members can attend a publicized and open meeting without violating the act to address a topic of state concern, for example. So there may be legislation coming that impact midwives. Everyone here is free to go to the hearing at the legislature to weigh in on that. But when you're there, you can't get together and talk about MAC business. Council social, for dinner, for lunch, perfectly acceptable, but be on guard that you're not violating the act. Because it's easy to do.
It doesn't say you can't discuss it, it says a majority of council members can't discuss it.
That's right.
So you can discuss it with another council member as long as it's not the majority.
Right, but if you are going to do that, you need to ask that person if they've already talked about this matter to another MAC member. Because very quickly, you can see how a serial communication can occur. So just be careful. And I'll get to why, at the end, but there are consequences that you want to avoid. So some of the things that are required for the meetings are advance notice. The agenda for a regular meeting must be posted 10 days prior to the meeting. And the fine print is unless an exception for a special or an emergency meeting applies. A special meeting can be held to consider, for example, proposed legislation, and notice is required 48 hours ahead of time. And for an emergency meeting, these can only be held if there is a work stoppage or other activity that severely impairs public health or safety, or a crippling disaster that severely impairs public health or safety. And if that happens and we need to call this council together, we have to provide 1 hour notice. That have to happen afterward to bring that into compliance with the law. So extremely rare, hopefully. Place needs to be identified and the business to be discussed. So the place, we're talking about the physical location of the meeting. From time to time, the MAC has done telephone meetings. And that is permissible, provided all the notice requirements are given. But you have to be at the noticed location. So you can all be in different places, but you can't change your mind about where you're going to be. If you are not at the noticed location, the meeting has to be canceled. So if that ever happens, and we agree to have a telephone meeting, please be at the noticed location. And if you're ill, the meeting can't go on without you unless there is someone at that location, another member at that location, ideally, who can make sure it's open and the signs are posted. So it's permissible, but it has to be complied with perfectly. So there can be additional locations where the public has the same access through technology, even if another member isn't there. And all locations must follow the rules on accessibility. So you want to do it at your house, you have to invite members of the public into your house, and it has to be accessible to people with disabilities. So the agenda, the notice of the meeting, has to describe the business to be discussed. And the description has to be sufficient enough to allow people who are interested in various topics to know, oh, this is coming up. So I want to make arrangements to be at that meeting. The agenda must include all the items to be discussed, and items that are not included on the agenda cannot be discussed, except to determine whether they should go on a future agenda item. So all the documents provided in the packet or passed out to members during a meeting, like the PowerPoint, that is a public document. It also has to be made available to the public, at the meeting, on the internet, and upon request by any member of the public. At open meetings, there has to be an opportunity for the public to speak, and that is provided at the beginning. We have an agenda item, specifically public comments on items not on the agenda, and then on each agenda item. And the chair must ask for public comment, on each agenda item, but also especially prior to any action being taken, so that the public can advise you, is this a good idea? Are there unintended consequences, other things that you need to think about, a better way of doing something? So this is an opportunity to make the best decision possible.
Someone didn't pay the bill.
We're all in the
So, in summary, the general principles are all meetings are open with limited specific exceptions, and the purpose is to provide a meaningful opportunity for the public to participate. So there are consequences if it's not complied with. One is that a decision made in violation of the Open Meeting Act can be invalidated through court action. And more significantly, each member of a state body who attends a meeting in violation of the Open Meeting Act and where the member intends to deprive the public of information to which the member knows or should have known the public is entitled to can be found guilty of a misdemeanor. So these are very important principles that the state holds dear. So with that, I'm happy to answer questions.
I have two questions. My first question involves group emails. So we have a California list, right? A midwife list, which many of the MAC members are on.
Say that again?
A list, an email list, or
Uh-huh.
is that what you call them? Group email list, right? So many of the MAC members, the midwife MAC members, are on that list. If the whatever is being discussed is not something that is likely to come before the MAC committee, is it okay for the members, more than 3 of the members, or 3 of the midwife members on the MAC, to give input into a discussion like that? It would always probably be about something with midwifery in California. We have no way of knowing whether whatever they're talking about is going to come to the MAC meeting at some point on the agenda or not. But because we've talked about it before, and we said, well, we have to be careful. We can't be commenting on this or that.
Right.
So what, is there guidelines around that, or is it just tricky?
I think depending on what the discussion is, it could be tricky. So, if you're saying, hey, I'm in this area, I need a physician to refer to, I think that's fine. An immediate practice question where you're helping each other out with referrals or experts. I think if it's about policy, which is your role here, on, hey, we need to change these regulations, we need to make a legislative change. I think that could pose a challenging problem.
Curious, isn't it also the issue of the person that's participating in the conversation is viewed by the reader as an official spokesperson from the organization that they are speaking from, and it hasn't been limited to, this is my opinion, versus the assumption becomes unintended consequences that the person is speaking officially.
I think that's a separate issue, because
Okay,
that
I'm
could
sorry.
happen even if you're not all on the same listserv. I
Okay.
think the
Apologize.
more concerning issue is that if the majority of you are on this listserv, and it can be seen as you're putting forth ideas and you're resolving questions and making plans that isn't in a noticed forum, that could be a problem.
I think another place that this comes up is sometimes those of us on the MAC will be included in an email. Maybe all of us will be included in an email amongst other people generated by somebody asking some question that relates to the business here on the MAC. And so
Now,
if any of us respond to that, now we're in a serial email. And so I think people need to just really be aware of that. The other thing that I do is, I don't respond to any of those, and I'm not on any listservs, so I don't have to worry about it. But the other thing is I have a disclaimer at the bottom of my email that says that anything in this email has nothing to do with my position on the MAC. And maybe you could send everybody on the MAC that language that then they could put on their email, so that even if you're not in some serial conversation, it's clear that you're not speaking for the MAC in the private email.
And going back to Ms. Holzer's comment, it's not a problem that you're on this listserv. It's if you know that it doesn't sound like she is, that Ms. Sparavon and Dr. Adams and that these other midwife members, or if they allow public members too, it's if one of you comments on it, then it's shared with all the other MAC members.
So anything that seems policy related or something that could eventually end up in the legislature or whatever like that, it's probably best just to refrain.
In that forum, you could speak to someone individually, not as speaking on behalf of the MAC, but you may have a colleague that you really want to encourage legislation, and you're free to talk about that as an individual. But it's if you're sharing your opinion with other council members in a non-public forum, that could be an issue.
You're also taking away a step of the whole process, and that is to have the conversation in a public forum where ideas are generated and put forward to better the process or to better whatever the need that's needing to be met. So if everyone's already had this ability to read this email, I never read them, so I'm not on your list. But if everybody's able to read that, that means that we didn't have to bother discussing it because it's already been everybody else has kind of taken the best practices and decided where to go. So you've taken it out of the realm of the public opportunity to participate. So I think that we all need to be very careful of when you speak to one person one-on-one, you speak one-on-one. When you are participatory in any kind of a listserv, you're there with your eyes are viewing as you are participatory in a quote-unquote meeting that's not in a meeting format, that's not an official, what we've just heard very well put to us. I want to thank you. I thought I knew most of this stuff by heart, but I guess I don't. But, so it's better for all of us not to do it, because if the idea is that it's going to be removed from, we could be removed from doing what it is we know needs to be done because of this, we don't want to take that opportunity and mess up.
Another question?
Oh, my second question has to do with something that you didn't go over today, but is in the Bagley-Keene Act about closed sessions. I did notice that there was one provision for closed session that said that, and maybe this is just in the definition, that we could do a closed session for, or, statewide bodies can do closed sessions for appointment, reviews, or dismissals of public employees. Because we've been trying to figure out the best practices for appointing people to the MAC and having it be kind of.
But that doesn't apply.
It doesn't
to
apply
the
because they're
MAC,
not public
right.
employees.
So the medical board does this to appoint and review and dismiss the executive director of the medical board. But council members aren't public employees.
They're not public employees, okay. So my town does this interesting thing, and of course they're under the same rules. When they appoint people to the town council, and they're not employees either because they're not paid, they do these interviews, but they do them in the room when the public is there, but they have the people who are potential people to be interviewed come up to the podium, like the council sits in fronts like this, and there's close chairs like that, but they don't have them on the microphone, and they get interviewed by the council. It's very quiet. People at the back of the room wouldn't be able to hear it. And then after those interviews, they later then nominate somebody and talk about it like that.
Local government is governed by the Brown Act, which
Oh,
has a lot of similarities to the Open Meeting Act, but it's not the same for every provision.
I didn't realize that the Brown Act and the Bagley King were different. My husband was asking me about that last night, and I'm like, I don't know.
Local commissions are also under the Brown Act, not the Bagley Keene Act.
And Bagley King is that's just state
State.
wide. Okay,
Yeah.
all right, that's the difference.
Does anyone else on the MAC have questions about this and your role and how it looks? Now, how about public comment? All right. Seeing none, we're going to move forward.
All right, thank you all.
Thank you, Carrie. Appreciate it. So, agenda item 6 is an update on the American River College program, and I have asked Kaleem Joy to give that report again because she did such a great job last time. Thank you.
So I'll just restate, I'm Kaleem Joy. I'm a licensed midwife and a certified professional midwife. I am on the advisory committee for the American River College in Sacramento for the development of a midwifery education program. And this is an update report to the introduction of this project presented at the last MAC meeting in August of 17. An advisory meeting was held at American River College on October 26, 2017, and it was well attended, both in person and virtual, by Kathy Fox, the professor at ARC, who is the program developer, as well as several licensed midwives, some doulas, Cam and Calm's president, CETA, which is Sacramento Employment Agency, as well as the nursing director at ARC and the dean of education. The following information was presented and discussed. It is expected that this December, where we're in, 2017, the course outline is due for completion, which will give the program structure of units, course names, and numbers. Second, the funding for the second year of the development was applied for. Third, there is continued communication with Sherry DeVries, who is a program director at Southwest Tech in Wisconsin, regarding the direct entry midwifery associate degree program that they offer. And I know that that is helping Ms. Fox to have some guidelines of how to create this program. Ms. Fox is being assisted by 2 licensed midwives, Sarah Davis, LM, and Rachel Fox Tierney, LM. They are working directly with her, providing assistance with labor market analysis as well as current program curriculum analysis and development. So the next steps are curriculum content development. Second, job market analysis for substantiating a need for continued yearly program development funding. Third, the evaluation of the program curriculum structure and contents of the current schools enrolling students in California. And the purpose of that is to provide a clearer understanding of how to structure a program which will increase academic success, skill proficiency, and overall quality of education for optimum outcomes of care provided by the new midwives. Fourth, preceptor requirements, training and availability. And fifth, there is a scheduled brainstorming and advisory meeting for January where midwives will be invited throughout the state, as well as student midwives, members of CALM's Equity and Inclusion Committee, CFAM, and other interested parties for the purpose of gaining their insight into important areas of curriculum structure, preceptor training and utilization, and solutions to current concerns in midwifery education. At the last MAC meeting, there were 4 questions that came up, and I just want to address those quickly. One was, will this program provide CEUs? And the answer is yes, because our current LMPA statute provides that classes taken at a community college that are related to the field of midwifery may be taken for 15 CEUs per semester unit. So in addition to that, the program will seek MEC accreditation, so CEUs will be available. Second question was the challenge process option, and that once the program is developed, then they can go about finding out if that is going to be an option that the board would approve of. Third was, would it provide remediation? And after the program's approved by the board, the medical board, and each individual midwife who might need remediation is evaluated by the board for what their education or skills might need to be for that remediation. It's a good chance that this program will be able to aid in that, but that can't be determined until the program is actually up and running. Fourth, how will clinical experience and preceptors be available and used? And this is an extensive topic in this committee and will be addressed at the brainstorming and advisory meeting in late January, and I will update you when there's more information on that. So is there any questions that I can take back, try and answer at this point? Yeah.
Did you say that for remediation, after the medical board approves it, and then after the medical board evaluates licensed midwives to see what remediation they may need individually?
All right, let me clarify. The program itself will have to be approved by the medical board that it accomplishes for a California education. Once that happens, then we can look at if there is a midwife who needs to have remediation. The board has to look at that individual midwife for what type of remediation she needs. And then, if they approve that there is something within that educational process that can accomplish it, then that will happen. In other words, we can't speak for what the board is willing to approve at this point. One, because the program's not finished, and two, because the board has to decide that. Knowing how remediation occurs, currently with physicians, they have a program, I believe, in San Diego, right? And we don't have anything like that yet. It's possible that this may be something that we can use in that way and that the board might find really helpful in that, but we won't know. You're welcome.
So just to clarify, as far as the medical board goes, they do have a program, but there are several programs that it becomes the responsibility of the decision of where that doctor is going to be remediated. It's not necessarily only
Okay.
in one location. There's other opportunities.
Right. Having gone through the process myself, I'm aware that as licensed midwives, we haven't had that as a potential, except to send them perhaps back to a school that is currently being used. So this may be an
This
option.
may be wonderful as far as an opportunity to fold it and manage it into what we need.
Right.
Super, thank you. Are there any other comments from MAC members?
I have a question. I'm curious what ideas you have for clinical.
So as I said, it's a big topic of discussion, and because we know that currently each midwife seeks out a preceptor in her local area or may move to an area for precepting, and that it is a one-on-one generally, some are in birth centers, that is one of the topics of discussion of how do we make this, number one, available to the students. How do we ensure that the preceptor has appropriate training and experience? And how can we ensure that they will come out of that clinical having learned what they need to learn? So that's where the brainstorming's really coming in, is how do we ensure that that happens from a community college position? We know that there are birth centers. We know that there are talk of certain birth centers both locally that are hoping to house students like that. So I think that Ms. Fox is really open to give me some suggestions, help me understand what does work and how we can make this a program that's really going to function. Is there anything specific that you want me to go back to her with?
Well, what comes to mind for me, I'm a Medi-Cal provider. I'm the only Medi-Cal provider in Los Angeles, and I can't handle the load. There's so many people that want care, and it seems like this would be a great situation for women who don't have access to care. The problems that we have right now are that we're really fighting the managed care plans right now to accept this care. So that's a whole other fight, but I think it would really be ideal to have a situation where we could work out birth centers that were willing to work together, like Maternidad de Luz or, places like that, but that we would be able to do and have different satellites where the students could go, and then you'd be serving the population also that isn't being served, and helping bring new midwives that are reaching a more diverse community as well.
Yeah. And that has been part of the discussion. So perhaps some of it is finding out throughout the state where those birth centers exist so that they can be referred to them as a possibility. I know that there is one local, and that is their goal, is to serve Medi-Cal and low-income and marginalized populations, and for the purpose of helping students to be part of that process. But I'll take that back to Ms. Fox and encourage that to become part of how we explore getting preceptorships. Yeah. Anything else?
Barbara?
I want to suggest that as a opportunity maybe to come up with some more ideas is to take a look, and maybe the medical board can be helpful, but each and every midwife who is midwifering, there probably are weaknesses that you've seen within what you're doing anyway, that if you had a little bit more insight or a little bit more education or a little bit more mentoring, you might not get yourself into issues where there might be a problem. So as a tool for prevention, this is a phenomenal opportunity. So that I would highly recommend that you speak with the medical board to make sure that any of the licensees who have had issues as far as quality care or issues of practice, but then also to take a look at the leadership within the midwifery world and ask where the people that they know and the people they've worked with, or the people they've heard about, where those weaknesses might be. Because if we can come up with prevention and education, it sure is a whole lot better than waiting until you've made a mistake or error, which requires you to go for this.
Absolutely. Can I mention about the other program? Is this okay now?
No, it's
No,
not, because it's not on the agenda.
Never mind.
We'll put it,
I
think
will
about
take
putting it on
that
for next time.
and really
Try and flesh it
talk
out.
to staff, yeah, and find out where those places are.
Is there any other comments or questions from the public? All right.
Super exciting, Kaleem. Thank you so much.
You're
Really
welcome.
excited.
That's great. All right, Ms. Gibson.
Just a very short comment. Faith Gibson. I have a friend in Palo, where I live, a labor and delivery nurse that is starting an online frontier nursing program, and they obviously are going to have the same problems we're having in terms of the clinical, so that all of the clinical is going to happen in the community rather than at a central location. So I will find out from her how they're doing it. That might give us some tips at least. Thank you.
Thank you. All right. No other comments? All right, moving right along. Ms. Simoes is going to talk to us about the Midwifery Task Force.
All right. So the Midwifery Task Force met via conference call on October 5th, 2017, and the task force discussed the regulations required by AB 1308 and possible next steps. The task force and staff discussed moving forward with the board's language, and that's the language that was approved at the April board meeting. But there's already a bill, which is SB 457, that would make changes to the same section of law. After discussion, the task force decided that the most appropriate course of action is to work with Senator Bates, who is the author of SB 457, her staff, and other interested parties on amendments that would be more in line with the language approved by the board previously, which will allow the board to finally develop regulations. The task force recommended to the board that they direct staff to work on amending SB 457 this year. If this is not completed, staff can come back to the board with this issue the following year. Since that board meeting, I've confirmed with Senator Bates' staff that the bill is not moving forward. So I've actually also been in meetings with Senate Business and Professions Committee staff, and they've committed to holding meetings with interested parties to try to resolve this issue. And so the plan is, and there's actually a member from Senate BNP staff here in the audience today, but the plan is that they're hoping that if Senate BNP staff takes on this and they become the holder of the meetings, they hold meetings at the Capitol, they bring in interested parties, that we'd be ready for a bill next year. And next year is the beginning of a 2-year session. So the hard thing was starting
Is that 18 or 19? Next year is this
Yeah.
coming year.
No, next year is 19. So this year, talking legislative session wise, this year it starts January 2018. So that is what I'm talking about when I say this year, because that's when the new legislative session starts. So this is 2018 is the second year in a 2-year session, which means if the bill doesn't pass in 2018, then it's dead and you have to start over in 2019. If we start in 2019, you actually have 2 years to get that bill. So if it doesn't happen the first year, you have that second year. And so Senate BNP staff thinks that's kind of a better course to try to get. I know that we've kind of tried to hold meetings, and it hasn't really, not everyone's come together, but I know that they're hopeful with Senate BNP staff getting involved and kind of holding those meetings, that maybe we can come to some kind of resolution. And the starting point would be the language that the board already approved, and working with everyone to try to hopefully get to some point of resolution. And I know that there's, like I said, Alyssa Silva's here from Senate BNP staff if you have any questions of her. But
So we wouldn't even begin discussions until January of 2019?
no, 2018. So we could begin discussions tomorrow. I mean, discussion doesn't require the legislature to be in session, but the legislature doesn't come back in session until January 3rd, 2018.
Okay, but we're not talking about a bill moving forward until
We're
the
talking about
2019.
meetings. So we're talking about meetings happening in 2018. Hopefully everyone can come to some kind of agreement, and then a bill being introduced in 2019. And the good thing about that is it's the first year of a 2-year session. So you basically have 2 years to get that bill through the legislative process. If we were to start something this year in 2018, we'd have this 1 year, tight deadlines. You have policy. I mean, everyone kind of knows how the legislative process works, but you have policy committees, you have deadlines. There's just more potential for it to get stuck somewhere, and then we'd have to start over anyways. And that's, just kind of the take. I don't want to speak on behalf of Senate BNP. That's kind of been what's explained to me. Our board obviously has voted already and said, we're not going to start something this year, 2018, that if we can't work it out, I'll come back to the board and, and hopefully come up with legislation for 2019.
Okay, so
This doesn't also prevent if private associations, like
I'm doing something right.
Right.
But what do we do as a state board in terms of, okay, the law was passed in 2013, we're now heading into 2018, we still don't have the regulations done. I mean, I know we've gone years and years and years in the past without creating the regulations that the legislature asked us to create, but I'm just wondering where that leaves us.
That leaves us where we are now. I mean,
Okay, so.
yeah. And we're working with the legislature on this too, as well. So
Right. No, I understand. I'm just, I know that in the past, it was a really big issue that we didn't create a regulation in 2003 that we were supposed to create, and it took years to get that fixed.
Right.
And I just want to be sure that everybody, including the legislature, understands that we're trying to fix this problem.
I think
but we
everyone's
can't fix
aware
it
that
through
we're
regulation.
trying, we were going to try to get something in our sunset bill. It didn't work out just with the introduction of another bill, and it didn't happen. And so I think the legislature is aware that we're trying to work on this problem. That's why we're trying to go the route of like legislative staff actually convening these meetings and bringing all the parties together and having meetings at the Capitol. And hopefully that will help people to kind of come to the table. We have a starting point, which is the language that the board approved of its April meeting that came out of our Midwifery Task Force's interested parties meeting, with that, kind of heard from everyone. And so that's kind of our starting point. But obviously we're going to have to kind of, work with all parties to see what we can get through. So.
Okay, so we're looking at something not passing and not getting fixed until 2019 at the earliest.
Well, unless, like I said, anyone can come to the legislature. I mean, it doesn't have to be the medical board that brings a bill. Yeah, so if a private association wanted to bring a bill, there's nothing stopping them. But this is kind of the process that I've talked to Senate BNP staff, and that's their commitment, that they've committed to helping us out by convening these stakeholder meetings.
Okay.
Yes, I think that what we all need to realize is that this is an opportunity to bring all interested parties and retch it up a notch. It's no longer just the medical board trying to fail through this opportunity, because people not everyone can agree on the same issues. What this is doing is literally ratcheting it up so it becomes more important under everybody's eyes. Everyone can be at the table. We are just one of those people at the table. The MAC is just one. The medical board is one. All interested parties, associations, registered nurses, whoever wants to be there can be there, and they're going to organize and orchestrate it and maybe come up with some solutions.
That's what we're hoping for.
Or we'll go on the way we're going.
Okay. Ms. Davis?
Please repeat the name of the BMP Senate staffer that's here.
Her name is Alyssa Silva. She's here in the place of Sarah Mason, who had another commitment today.
Put her hand in the air or something.
There she is there. Thank you for being here. Appreciate it. So might it be a reasonable assumption that if somebody else were to get a bill authored that contained the language that the board's already approved, that the board would continue to be okay with that?
Yes, the board already approved to put it in our sunset bill. So yeah, I mean, I would take it back as this is the bill form, this is language you already approved, and I would recommend that we support it. So
Okay, thank you. Are there any questions from the MAC? Any questions from the public? Nope, seeing none. All right, we're moving forward. All right, agenda item 8 is an update on the continuing regulatory efforts required by Assembly Bill 1308. Ms. Webb.
So this follows nicely Ms. Simo's presentation because they are very interrelated. And as you all know, we've met many times. We've had several interested parties meetings attempting to come up with a compromise on the regulations to define pre-existing maternal disease or condition likely to affect the pregnancy and significant disease arising from the pregnancy. There was a lot of areas of agreement between the stakeholders, but the impasse really seems to be mostly about VBACs. And we need a legislative change to address the issue and the language requiring a physician determination. We need some adjustment to this language so that physicians can participate in a way that doesn't get them in trouble with their insurance companies and that benefits collaborative care so we can protect consumers. So it's in process.
Thank you. Any questions or comments from the MAC? No, how about the public? Anybody have any further questions on this wonderful issue? All right, seeing none,
My question is, what is the next step? What's the next plan step?
legislation.
So Senate BMP committee has kindly agreed to coordinate interested parties meetings and to hopefully create a vehicle for the medical board to put in its approved language or language very similar to that the interested parties who we thought were all in agreement at the earlier task force meeting, everyone can live with this, and it provides the framework necessary to move forward with the regulations. So once we get a legislative fix, staff is prepared to move on the regulations, which we probably need to revisit with another interested parties meeting to see if we're still in agreement with what we had talked about a couple years ago. So that's the next step is Senate BMP coordinating interested parties meetings.
Okay.
So does that mean that the language is in the process of, we have something that we want to show them that somehow, so we don't have, there really isn't anything that anybody's agreeing with?
Well, there is a draft legislation that the medical board has approved that will have a physician make an assessment rather than that the midwife would have to consider in determining whether this person is an appropriate client for midwifery care.
Is it possible to propose that there is no physician needed to determine that? Is that, so that,
by law.
But making an assessment is different than a determination that this person is appropriate for continued midwifery care. So the midwife will be making the final determination under the proposed language within the midwifery standard of care. But, obviously, depending on what the physician finds with the examination, there are some things that need to be referred to a physician.
so if the doctor makes the assessment and says it's not a good idea, then the legal responsibility falls back onto the midwife to say, well, I understand your assessment, but my assessment's different, therefore I'm taking the legal risk.
That is
That's
a
basically
potential,
what we
right.
want.
So I have a question because I'm not clear why Senate BNP needs to hold interested parties meetings when the board already did that. The interested parties agreed on language. The board agreed on the language. I don't understand why we have to go a whole nother year doing meetings when we've already done the meetings.
Because CMA and ACOG still have issues with that language.
Okay, so even though they agreed to it, they still, okay.
I don't know if they necessarily.
Why doesn't that surprise me?
I think this is an opportunity, in all due fairness, I think this is another opportunity to try and see if we can find some common ground. And the common ground has got to come from the people that are not agreeing with us at the moment, ACOG and CMA, and along with our staff who've already gone through this and approved it, maybe they can work out some other mutual agreement that might satisfy everybody.
I think everyone kind of agreed to the concept in that meeting, but when the rubber met the road and we actually sent that language out, there wasn't necessarily agreement for everyone. Is that correct interpretation?
There appeared to be agreement, and then there were some parting comments at the end that
Right.
I understood to mean they were going to do something different anyway. So
Which
this
they did. Then they
That was the Bates bill.
introduced SB 457, which would have basically deleted the section we were making changes with, which is the reason why it was difficult to bring another bill in where one would delete it, one would make changes to that same section of law. So
Okay, do we know on the record what the disagreements are?
that's kind of the purpose of the interested parties meetings.
Okay, so we don't currently have anything formal that would inform us what the disagreements are.
I think if you looked at the Bates bill, you would see what the areas of disagreement are.
I'm noticing that the lobbyist for the California Medical Association is in the room, and I'm wondering if you'd like to inform us on what those disagreements are.
I'm actually not I wasn't the lobbyist this bill.
Okay, thank you.
I have a question or a comment, rather. I just would like to make sure that as we move forward with this, if we do move through Senate BNP, that we have stakeholders from the public at these meetings, from CFAM or other methods to get the public actually involved in the meetings.
I totally agree. Yeah, there needs to be outreach to California Families for Access to Midwifery Care, to the California Association of Midwives, which is now a consumer group, and to make sure that both of those groups are represented in these meetings, because it's really about our consumers. It's not about what midwives can or can't do. It's about what women can or can't choose or give consent to. Please.
Kelly Olmsted, licensed midwife. I don't know when or if this is the appropriate time to bring this up, but if we're talking about legislative fixes to AB 1308, are we also looking at the 42-week issue?
I'd have to refer you back to your state organization.
Okay.
Because I don't think that was originally the intent of all the discussions that the medical board has held. However, because the medical board can't make that decision because it's in statute, it has to be made by the legislative body. If they want to change that particular phrase, they can do that, but the medical board doesn't have any control over that at all.
Got it. Okay.
Anybody else? All right. Seeing none, we are moving on to agenda item 9, update on proposed regulations for midwife assistants. Ms. Webb?
Well, I do have good news on this. So the midwife assistant regulations authorized by Business and Professions Code Section 2516.5 have been approved and became effective September 21st, 2017. They are set forth in Title 16 of the California Code of Regulations, sections 1379.01 through 1379.09. These regulations set forth the requirements for training that must be completed before an individual begins providing supportive services as a midwife assistant. Such preliminary training requires certification in neonatal resuscitation and basic life support and training in infection control. Additionally, they must receive didactic training in midwifery and training on administering oxygen by inhalation and how to provide immediate care for a newborn for the requisite number of hours. If the midwife assistant will be using an auscultation device to listen for fetal heart tones, administering injections or performing skin tests, or performing venipuncture or skin puncture, there is additional specified training involved. Training in these topics must include instruction and demonstration in pertinent anatomy and physiology appropriate to the procedures, choice of equipment, proper technique, including sterile technique, hazards and complications, patient care following treatment or test, emergency procedures, and California law and regulations for midwife assistants. A licensed midwife or certified nurse midwife can provide this training. The midwife is responsible for determining the content of the training within this framework and the proficiency of the assistant. The midwife must document on a certification the date, place, content, and duration of the training, and that the midwife assistant was observed to demonstrate competence in the performance of each task. The certification must be signed and dated by the midwife. This must be kept in case questions arise. Eventually, there may be formal training programs offered for midwife assistants, and such training programs must meet the requirements set forth in Section 1379.06. There must be a specific authorization for each task performed by the midwife assistant documented in the client's record, or a notation of a standing order authorizing the performance of a specified task or tasks. I can't stress this enough. If you are going to use a midwife assistant in your practice, please review Business and Professions Code Section 2516.5 and the regulations for midwife assistants. So you are entrusting this person to be your other set of hands. It is as if you are doing the work yourself. You are responsible for this person. So make sure that you review the law and that you set up a way to ensure compliance, and the training and the authorizations, those need to be documented and kept. And with that, I conclude.
So I'd like to ask you a question about the standing order, because I think that some of us might not be as familiar as others with what that actually looks like. So rather than writing an order in the patient's chart every time you want your assistant to take a blood pressure, you could have a sheet of standing orders that went into somebody's chart that said that your assistant with their name is authorized to do the following list of things. Am I understanding that correctly?
That's correct.
Okay, thank you.
That's pretty much the same as standardized procedures and protocols that you develop in practice.
Right. But am I right that it would have to be in each patient's chart? Or could it just be part of your policies and procedures for your practice?
You would have to note in the patient's chart that this midwife assistant is operating under the standardized procedures. So that,
So the procedure wouldn't actually have to be in a part of the patient's record, just a notation that this particular assistant is operating under those procedures, which can be found wherever they can be found, correct? In the midwife's practice documents.
right, as long as you can put your hands on it if a question develops. So you're free to include it in the chart, but you have to be able to put your hands on it if the board asks for it.
Got it.
Can I ask? I mean, I think that there are many midwives now who are on electronic charting. So I'm just trying to get a better idea visually of how that would work. When you sign into an electronic chart, each person who is charting's initial goes in every time they performs or they chart. And at the very beginning, their role is listed. So if they're an assistant or if they're a student or the primary. So how would something have to be changed other than that, or?
I think I'm only really familiar with mobile midwife electronic record, but there's an ability to upload documents by photographing them and just uploading them. So you could include in that section your standard protocols and procedures for a midwife assistant. And then when you first begin taking care of the woman or your assistant changes, you could just note in her record and part of the chart notes as Susie Smith is the assistant for this woman and she is following the standardized procedures that are in the document
Could
section
that
of
just
the
be
chart.
in your consent to treat?
It could be, but then what do you do if you change assistants in the middle? It doesn't need to be, I mean, like, I wouldn't think that the client would need to give permission right, by a particular assistant any more than she would have to give permission to be touched by you. So,
Well, in the consent now that midwives have, it says that we have students, those of us who have students, in the consent to treat, that will be.
right, but a student is different than.
Right, no,
an
that's why I'm
assistant.
asking. Can it say that we have trained midwife assistants and students, and then it's noted in the chart that that is the person with their title that's.
So can I just say, there's not a specific requirement for how it's done, so that may be perfectly fine. Someone else may do it a different way. It just has to be documented.
This is the hardest part of midwifery.
Yeah. But that's just what I want to emphasize. We don't have to get into how it's done, because there's discretion with how you want to do it in your practice. It just has to be done. It's like how you do this training. There is discretion with how you do midwifery didactic training, but it has to be for a certain number of hours. So you can, decide what you're emphasizing and what you're including. It just needs to be, appropriate and for the certain number of hours, so you can provide safe practice.
So I just want to make sure I'm understanding right. So it sounds to me like one of two things need to happen. Either every time you have a midwife assistant do a task, you have to create an order in the patient chart for her to do that, or you could just acknowledge that Susie Smith is the midwife assistant and she's following standard procedures and protocols that can be found,
Or
and
as
then
by
fill
directed-
in the blank. Yeah.
Or as by directed by her supervisor.
Yeah.
Am I correct?
Yeah, that works.
Does that help?
And there may be some people who have assistants currently that
Don't meet the
now
requirement?
don't meet this. So
Fix it.
fix it.
So I would like to suggest that we all have in front of us, at least up here, and I would hope the audience has as well, the lists of the regulations that have been approved, which has been a big deal. I think that we all need to realize that we identified an issue, we identified a problem. The team went to work from the medical board, and the staff did an amazing job. You guys all did. And I think it's something everybody has to read, and it needs to be part of what you do on a go-forward basis. And this is really, it's serious, and don't take the opportunity to, once you've been given an opportunity, don't take it and don't take it seriously. And this is really serious. I mean, this is really,
Don't mess it up.
don't mess it up, guys. Please don't mess it up.
Thank you.
And the risk, of course, is the midwife assistant can be, I say midwife assistant can be accused of unlicensed practice, and the midwife can be accused of aiding and abetting.
Be disciplined.
It can be a really big deal if you mess it up. So don't go there.
Seriously, I mean, is there a way actually to take these 4 pages and put it into publications around the state where others will read it? I mean, is there something, the public noticing, can you help us with that as far as getting the
Wondering-
word out?
Ms.
On
Davis,
your-
I'm just
on your
wondering if,
group
yeah, maybe.
email?
Colin can do that. Yeah, not me, I'm not on it.
Whoever's on that group email.
So the Calm Quality Improvement chairs are here today, myself and Sharon Potager, and we'll be doing a webinar and training on this
Fabulous.
issue,
Thank you.
including some suggested informed consent
And also
documents
to
and
consider posting
standing
this. I mean,
orders and all
post,
that.
I mean, they're very readable. Even I understand them. So,
Send them out.
send them out.
Please
you.
include the B&P code section with that, because it has, an extensive list of the tasks they can perform.
I'd also like to ask staff to please include these regulations in our Midwifery Advisory Council packet so that we have them on the desk, because I don't think they're in there yet. I don't see them today. Thank you. Any other?
Yeah, I just a clarification. So even though the board was involved in the regulations and you can get, prosecuted for it if you're not following the law, the board really is not involved in, for example, registering midwives or making sure that they're doing their CEUs or having a list of them or midwives assistants.
Oh.
Or, no, we're
Yeah,
not going to
we-
be involved at all, right?
There is no licensing or registration required for midwife assistants. So it's just like medical assistants.
Like an apprenticeship.
It's really up to the licensed midwife to select the person that meets the basic requirements. They have to be 18 years old and then have the appropriate training. And you don't have to tell the board that you have one. It's just all on you to make sure the person has the appropriate training.
Okay.
All right, anybody else?
And supervision.
Yeah, you
So
have
you
to be
can't-
there.
Have to be there.
Don't send your assistant ahead of you to check on somebody before you get there, just like you don't send students ahead of you to check on clients before you get there, because that is not allowed. All right. Nobody else? Any other public comments? All right. Seeing none, we are moving on to agenda item 10, which is an update on the revision of the transfer of planned out-of-hospital delivery form. Ms. Webb?
This form has not been updated yet. We really want it included in our new legislation so that the form doesn't come to the board and it goes just to Maternal Quality Care Collaborative or OSHPD, and there needs to be additional information on this form to make it useful for data collection. And we had reached a couple of years ago a tentative agreement for a robust form, and the California Hospital Association objected to it. So upon further discussion, we were going to go through regulation, but we really think that the form should not come to the board, because then it puts the board in a position to have to look at it as a potential complaint, when that is not the purpose of the form, because transfers should be done when they're necessary and not have the fact that there's a transfer be looked at with a questioning eye as a potential complaint. That's discouraging, and we want a legislative fix on this because it would benefit consumer protection.
So I have a question. Since we have a form that the hospitals are supposed to fill out and send to the board, it seems to me that it's in the best interest of everybody involved if the hospital's doing that accurately and appropriately. And I'm wondering if it might not be helpful at this point to have a task force that could work with staff to create recommendations for an interface between staff and hospital administration, so that the appropriate people at each hospital that are going to be filling out the form understand how to do it. So, anybody have any thoughts on that? Like, I'm just looking at, okay, if we're not going to get legislation on this until we deal with the 1308 problems, then we're 2 or 3 more years down the road with forms coming to the board that are often not filled out appropriately. And I think just looking at the number of forms that have been submitted in the first quarter, there were probably more transfers than that. And so it's like we've got a hole that where there's not good compliance with some of the hospitals. And so I'm trying to troubleshoot in advance for ways to fix that. Maybe we don't want to do anything more on it at all until we get our ideal form, but just wondering if anybody else has thoughts on whether that might be helpful.
So let me ask you a question. When a patient has to be transferred to a hospital, is there anything preventing the midwife from notifying the appropriate entity, be it the medical board or OSHPD or Department of Health, whatever, that they in fact have done it, just as a FYI for your information? This is the name of the patient, this is the date it was transferred, and just to make you aware of? I mean, is that?
I think to include the patient's name would be a HIPAA violation.
Okay, so.
And it's really on the hospital to do the form. So,
Okay,
like,
so
it
then that
shouldn't
won't
be
work.
on
So
the
the answer's
midwife to do it. Yeah.
The answer's no.
I don't think, after speaking to my peers, I don't think that I don't think every midwife is interested in the responsibility of this form. I think many midwives' attitude that I've come across has been, it's not my responsibility, I'm not interested in doing it. And so it's the hospital's responsibility. And also, many midwives are having, I think, I personally love this form because it's created responsibility for the staff to communicate with me. It's also created a situation where now we have a transfer of care plan from my birth center and my home births to the hospital, which other midwives are benefiting from now. So for me, it's been great. But most of my peers have said, I'm really not interested in dealing with that. So what's difficult is how much responsibility do we have for this, and how do we ask hospitals to comply with this unless the midwives in the area are interested in going in and seeing this as something positive. I think that helping midwives, maybe this can come up, helping midwives understand how it benefits us to create a situation where the accountability is there and the client, I call them clients, some people call them patients, are benefiting from the, I hate to call it forced communication, but it does start out sometimes as forced communication.
It's also continuity of care.
It's all things good for the client or the patient to have this communication going on. I think that it's clear from the law that the onus is on the hospital to submit the form. And I think it's also fairly clear that they're not always doing that, nor when they do it, are they doing it appropriately all the time. So then the question is, ahead of getting any legislative changes on this, do we want to better educate hospitals about their role and what they're required by law to do? Or do we want to wait until we get a different form? So that's the question that I'm asking.
I can tell you that a newsletter article went out, and that Ms. Kirkmeyer has met with California Hospital Association and described this process and explained that it is a legal requirement. Okay. So there is outreach. Right now, a lot of resources have not gone to it because of the issues I've mentioned.
Right.
And, certainly we can talk about doing further outreach on it, but it definitely will occur once the change is made so that the forms are going to an appropriate entity.
And I've dealt with probably 15 hospitals in Los Angeles that are within my immediate area. And the best luck I've had is when I've gone directly to risk management. Risk management is great about understanding the importance of getting a hold of head of L&D and making it happen.
Can I make a comment on this form? I agree, it's not the midwife's responsibility, and I think there's I think the responsibility is not, I think that as midwives, you need to let go of that responsibility. Your responsibility is to maintain accurate medical records, documenting your communication, because if there's any, we do want continuity care for the client, you're going to do that verbally. If you're not able to communicate with the physician as you're supposed to, then you document that you're not able to do that. So if there's any repercussion from the form, your records are going to be obtained. You're going to have the documentation. And, if you've documented accurately and completely, it shouldn't be a big problem. I think we spent a lot of time on this form that's to help the hospital, but I don't think it's necessary to spend so much energy on it.
I agree with the documenting. I always document who I handed the copy of medical records for, when I called the hospital, who was the charge, who the physician is and it will be receiving, or laborist. It's always all charted. So maybe that also needs to be something that we bring up to midwives, is understanding what our responsibility is, so that should we ever need to have that documentation, that way it's documented.
Yeah, Ms. Gibson?
Faith Gibson, California College of Midwives. I do more transfers of care than I'd like to talk about, but my experience with the various different labor and delivery rooms and the hospitalists and so on and so forth is that nobody knows what they're doing. And what I've done and what other midwives have been doing is I fill out the form myself to make sure that all of the information is there, and then I give them my chart to Xerox, which means that they're going to have my first half of it. In other words, I can't sign the physician's name. But I know you're talking about that the midwives don't want to be responsible, but there's not very much information. It's just a few, on that first page is very short what the hospital and your name is and that kind of stuff, and who you do get to say whether or not you actually talk to the doctor or they decline to speak with you, which is very helpful. And while I would like to see the content of it be more workable, I don't see any reason why midwives can't do that part right now without us having to get any laws changed.
So I guess there's two questions here. I think that what you're suggesting is a great way for midwives to handle this problem if they want to. But the onus really isn't on the midwife. It's on the hospital. And so my primary question here is how much in resources do we want to commit to educating the hospitals that this is their job prior to changing the law, which it seems to me might be 2 or 3 years down the road. So that's really my question. We can't compel midwives to fill out the form and give it to them. I think it's a great suggestion. If midwives want to do that, they can do it. But the bigger question is, how do we get hospitals to comply?
What I see is on the other end of that is like every hospitalist is, they often only work 12-hour shifts once a month or something like that. That at the granular level, to get to all of those people are involved. There's not a simple, like going to risk management is nice, but getting to every single person just doesn't seem to be.
I think if you
likely
train
that
the
works.
staff that's there the majority of the time, then they can interface with the doctors that are only there 12 hours a month and say, you know what, you got to do this. I mean, that's where it has to come from the hospital. That's the only way that we're going to ever get compliance on this.
After 25 years in a hospital, as soon as somebody changes, all that information is lost. Or with all of the paperwork that they have to do, all of the charting they have to do, where was that form? Oh, I think I remember that. Where'd you put that? Oh, I don't know. That's what happens.
Yeah,
So I
no.
think it's a whole lot of work, and there's not the benefit that you're going to get. I think it's a great idea to fill out the form and have them copy it, and then you have that. But I think it's too much time and energy spent trying to hand feed them what they're supposed to do. They're grown-ups. They're organization.
It doesn't sound to me like we're going to be able to fix this today, to be
It
honest with you.
it is risk management's responsibility to have an out-of-hospital transfer of care plan. It is their responsibility to have that, which
Well-
includes this form.
Okay, so let Ms. Davis speak, and then I want to say one more thing.
So how big is this problem, and what is the problem?
Okay, in my head, the problem is that not all transfers are being reported by the hospital, and when they are reported, often they are reported inaccurately.
Do we have some numbers, like percentages or anything?
The
That
ol-
would be really helpful for my mathematical mind.
I think the only way to figure out numbers and percentages, well, the best way would be if we were collecting numbers of transfers specifically as a number from midwives on the Elmar, which we're not. And the second way to look at it would be to add up outcomes after transfers from the Elmar and then look at the number of transfer forms that were actually submitted, because the board gives us those statistics. So I think there's a way to get the numbers. We haven't fleshed them out in those particular terms, I don't think.
We have the numbers.
Yeah, we have the numbers for the number of hospital forms that have come in, but we don't have a discrete number for the number of midwife transfers of clients. That's what we could come up with it closely, but we don't have it as a discrete number on the
So what's
LMAR.
happening is that from the statistics that are being provided by midwives, we know that the numbers are not matching up with the number of births that they're providing and the number of births they started out with, and the difference are being birthed in a hospital. Is that what you're suggesting?
No, what I'm saying is that on the LMAR form, we have to report the
you transfer?
outcomes after a transfer. So from that number, we could glean maybe the number of clients who actually got transferred.
Right.
And then we could compare that to the number of transfer forms hospitals submitted.
Now, is the whole problem that we just don't have 100% add up?
That's, in my estimation, that's part of the problem. And the other part of the problem is that often what we have heard is that hospitals are putting in things that are less than helpful, like failed home birth as the reason for the transfer to the hospital, when maybe what the midwife transferred for was because the woman had a lot of bleeding.
Okay,
or
but
whatever.
the issue is not, the issue is with the information that we are getting, where is the downside? You're suggesting that hospitals are putting in inappropriate information, but where is that affecting the job that midwives do or the statistics that the medical board is collecting or OSHPA is? I mean, is there a real problem that we can fix? Or it's just suppositions of,
We could get actual numbers, and I'll address that in my report on changing things in the LMAR. So we could know concretely how many transfers there were and how many hospital forms were submitted. We could have those numbers in a couple of years. What my biggest question here is not what midwives should do, but do we want to devote more resources to educating hospitals about their need to get this form filled out, or do we just want to let it ride until we seek different legislation so that we only educate them one time? I guess that's really the question that I'm bringing
so
right
I know
now.
that what you're trying to do is fix the problem, that is perceived that we don't have the complete information. But from a staff perspective, Ms. Sparivon, what would you recommend? We're not going to fix it today.
No, my recommendation, what I was asking people to discuss was, did we want to have a 1 or 2 member task force that could work with staff to come up with solutions for educating the hospital on their need to do this and how to do it, which could also benefit us down the road when we have the ideal legislation in a new form. So that's the only question
So
really
I
that I'm
apologize.
bringing.
I didn't mean to say Ms. Sparivon. I meant to say Ms. Webb, so I do apologize.
well,
But thank you for that recap. I'm just suggesting that this is going around and around and around. So Ms. Webb, I think that it's time to figure out what your recommendation is, and let's move the agenda here.
Well, I can't
Make a
make the
recommenda-
call
Okay.
about what this body wants to do.
Okay, so be it as made, would you suggest that Ms. Sparivon speak with Ms. Kirchmeier to see if a task force would be appropriate or relevant, or put the ball back in the staff's lap?
Let it be.
Or just kick
Right.
the ball
I mean,
down the road?
I've given you the roadmap of what the plan is. And I know that Ms. Kirkmeyer meets regularly for presentations with California Hospital Association, and this is brought up. And I think I've said
Okay,
what
here's my
roadmap
solution.
is.
Let's kick it down the road to the March meeting and get some input from Ms. Kirkmeyer about whether she thinks it's a great idea, and members can think about it in between now and then as to whether they think there's any reason to do anything differently now.
But I would also bring to the table some numbers, if there are numbers, to be able to figure it
Yeah.
out. So are we talking about 5 births in the state? Are we talking about 500 births in the state? If it's, it may not warrant the time and energy that you're putting into this. And I could be wrong, I have no clue.
Well, we're getting about 200 hospital reporting forms a year. I think I'm pretty close there.
So 200's a big number.
But we have 4,000 midwives that are or not 4,000. We have 400 midwives that are practicing, and it's about 4,500 births. So
You're talking about 4,500 births in the state a
Yeah,
year.
right.
And
So-
200, so you're talking about less than 10%.
right,
Talking about
Which-
5% approximately.
which may be accurate or may not be. So
I think with the limited resources that this staff has, that it would be better for the consumer, for the clients or patients, to have education in the hospital about what a licensed midwife is and does, and the scope of practice rather than this form.
yeah, but we're stuck with the form because the
Right, I
legislature
know.
said we had to have the form. So
No.
then for me it becomes, are we doing our job in educating hospitals? I mean, is that our job? And if it is our job, then
Can I say, as a midwife, what I'd like to know is, I always want to know the risks and the benefits, right? That's what we all want. But if we just say we're really not interested in this because we have so many other things happening right now, but if actually not reporting or not pushing this affects future legislation for us because only certain things are being reported and not, oh, well, I've transferred care because she was 35 weeks and ruptured. Is this going to affect us later? Because I would like to believe that we're all transferring with good cause. And if it's always reported that we are transferring because it needs to be done, and we're having better outcomes, that it's going to help us. What are
That's
these
a really good
statistics
point.
really doing for us? And I think if it's presented to midwives that way, as a risk-benefit issue for us down the road to protect us, then if I look at it that way and I see that the benefit is greater, then this would be at a higher level of concern. And I think that's, for me as a midwife, what I would be looking at.
all right. So is everybody okay with just kicking this down to March and getting more information from staff about what has been done, what's ongoing, what Ms. Kirkmeyer is actually doing, and we could revisit it then?
Sounds good.
Okay. Whew. Any other questions or comments?
Yeah, you got some.
Maybe you just want to remind everybody in the room what the overall goal of collecting these forms is.
Yeah, so the overall goal of these forms initially was to provide better information and better tracking of why midwives were transferring clients to hospital, and what that actually looked like. It was designed to improve outcomes, to find places where we could improve care, particularly in that transition between home and hospital. How could we work better with providers at the hospital end? So that was the original intent. Sorry, go ahead.
Laura Perez, licensed midwife, certified professional midwife. I have a question for Carrie Webb. When you started your presentation, you mentioned that there was concern about presenting the form because there was a desire potentially to make it more robust and more appropriate for data collection. I don't know if you can speak more generally or specifically to what you meant by that.
Well, we, when the law came out, we had discussions with ACOG and CMA and CAM and came up with a multi-page form that we thought collected very interesting information that would be useful to get a good picture of what was happening. And then it was shared with California Hospital Association, who said, we won't do this form voluntarily, so you have to go through the regulatory process. So we started to do interested parties meetings on that, and then the issue about where the form goes became primary. And that's because every piece of paper that comes to the board is evaluated whether it should be explored further as a complaint. And the discussion was that isn't what this form was meant to do, and could have a chilling effect. And so even ACOG was very supportive of having the form not come to the board, so that the data collection would still occur, but the board wouldn't have to evaluate whether this should trigger a complaint, an investigation. So I think that's really important, and that's what we would like to see happen, is that change occur.
And that sounds more like a process change from what I'm hearing you talk about, but I guess I'm asking specifically if you can speak to how the form might be altered. If you talked about collecting information, what would that mean? If you know.
I mean, I can't speak off the top of my head, but it was several data points on the reason for the transfer and what happened thereafter and who was involved.
I think one of the things that we had talked about doing was using the list of reasons for transfer that we have to submit when we do the LMAR, so that that those two correlated, so that there weren't just random inputs by hospital staff about why the woman was there, that it could correlate. They'd have to pick from the same list we have to pick from on our LMAR. That was one of the data points that I remember us talking about. Thank you. Any other questions, comments?
I think that's good.
All right, great. Moving forward, Ms. Simoes is going to update us on midwifery legislation. And if you could just one more time say, using the year, what the current year is.
Okay.
Thank you.
These are all bills that passed in 2017 that become effective January 1st, 2018. Well, the one that passed, AB 1612 Burke, the CNN bill. That bill is actually a 2-year bill, which means it didn't pass this year in 2017, so it possibly could move in 2018. 2-year bills have a really short timeline, so we'll probably know at the beginning of 2018 if it's going to move or not. SB 457 Bates, we've already talked about this bill. I've confirmed with the author's office that this bill is not moving, so if it doesn't move this year, that means it's essentially dead. SB 798, that's the board sunset bill. This bill did get signed into law in 2017, so most of the bill becomes effective January 1st, 2018. There's some sections that are delayed implementation, and those sections are marked. The bill did get signed into law with the provisions that include licensed midwives and the peer review reporting requirements, and they also add licensed midwives to the listing of medical corporations. So both of those were retained when the bill was signed into law. So that concludes my presentation, unless there's any questions.
Can you tell us a little bit more about protected peer review, please?
A little more about protected peer review?
Yeah, or maybe Ms. Webb can tell us, because I know that there are a lot of midwives that aren't really understanding what that means or how that affects them.
So basically, it adds licensed midwives to the 805 sections of the Business and Professions Code. And so it allows for protected peer review. It allows, I believe it's to the section related to associations. So obviously there's peer review bodies and things like hospitals. Midwives don't have that same kind of thing. So it adds them to the association section. And so it allows for peer review, but also requires peer review reporting if there's an incident. And maybe Carrie can, or Ms. Webb can help me out a little bit more, other than if you want more specifics than that.
So they would fall under 805 A 1B3 for Midwifery Professional Society. And this is, if you're doing peer review and a midwife is, their membership is terminated for a medical disciplinary cause or reason, then that needs to be reported to the board. Or if they're denied membership for a medical disciplinary cause or reason. The peer review, it is confidential in under the evidence code, but the board can have access to those documents and then determine whether discipline is warranted on the license.
So documents that would be created by the peer review body?
Yeah.
Okay. So what does it protect? Does it protect, like, if I'm in a peer review and somebody is...
No, wait. Explain maybe what a peer review is, because the question with peer review is that you're in an organization that for cause you would be brought up on charges, or you would be disciplined, or you would be released from your job, or that kind of thing. And then they would take people from your profession to evaluate if what in fact you did was according to what has been defined by pieces of paper. So if you have a peer review group saying that you were not guilty, that you did not do that, you were fine to do what you did, that's peer review, correct? And I think that there's
a particular definition in 805.
But I think that there's a past tense or past. There's a missing link here in what's being asked.
I guess
She's saying protected peer
if we're
review.
having protected peer review, what is protected? Like, what does that mean exactly?
In civil cases, if you're doing protective peer review, then someone can't get those documents of the peer review body to use in a civil case.
But the medical board could get them to use in a disciplinary case.
Yes.
Okay, that's what I wanted to know. So it isn't a protection of one member of peer review from other members of peer review testifying against them.
That wouldn't happen in a civil case. And the board investigators would try to get evidence if they were going to take disciplinary action.
So primarily it's a protection against civil cases.
Yes.
Okay, that's, I guess, what I needed clarification on. Ms. Davis?
So Calm put forward this language and provisions into the Sunset Review Bill, and our lawyer has interpreted it as that it's under a medical, like in a hospital where there's employment, that's different reporting that will be necessary from if it's happening under a professional association, because there isn't employment or disciplinary things that are happening typically under a professional association.
Yeah, I mean, there's provisions that apply to professional society versus
A hospital.
a hospital or a medical group.
Right. Okay. Just want to be clear about that.
All right. Anybody else have questions or comments? Anybody from the audience?
So the medical board could ask somebody to testify against a case that they heard in peer review.
No, you're taking this, and this is where the past tense and the present tense are getting mixed up. I apologize. If you, and I'm using this with the medical versus if you are a doctor working in a hospital and you do something, you would have peer review at the hospital that would evaluate whether what you had done was appropriate or inappropriate. As a midwife, somehow you're covered in some kind of an association, which I'm not quite clear on. But by the same token, if there's something that goes wrong with a midwife and a case is open, you would have a peer that would be evaluating what it was that you did. Was it incorrect or was it correct? that review, I think, is what you're asking about. Is that open for discussion or available to anyone else? And that's where I think that we're not talking about apples and apples. We're talking about apples and tuna fish here. But I could be real wrong. It's not even apples and oranges.
So
I'm
It
not
only
sure that
protects us against civil suits, basically.
Right, it's nothing to do with what this MAC has to do with, I don't think. Am I right? I mean,
No, I'm
no.
just trying to,
Can't-
be the devil's advocate and ask questions that I know other people are going to ask.
So my understanding is there is a group, the midwives are required to do peer review. There's a group of midwives that do peer review and cases get presented. And in that discussion, there's a decision made. This action was appropriate, this action was equivocal, this action was below the standard of care. And that's put in the peer review documents, and it sits there. If there are enough cases, or if there's a particular member of that group, and the group says this person can no longer be a part of this group because their actions are inappropriate, that's reportable. But that's reportable. That means that organization, that group is responsible to report that to the board. Now, most of the peer review, from my understanding, it's not really an organization that you are brought in. You can just come.
Right.
So it really isn't going to apply.
Right.
If there's a complaint from someone else and there's been a peer review and there was that decision made, those documents are protected in the civil case, but the board can ask for those documents. Not necessarily somebody to come sit and testify. They usually ask for documents.
This is very document heavy rather than seeking testimony, but I can't speak for how our investigators, do their work. Not everything is reported, as Dr. Adams said. So for a professional society, it would be a dismissal or a denial. For a medical disciplinary cause or reason. And there's a definition in the law on that.
So you're suggesting that CALM could kick someone out because they were not appropriately midwiferying? Is that what you're saying? Kind of? The professional organization CALM could deny membership to a midwife that's licensed in the state of California because of inappropriate behavior or practice. Is that correct?
Yeah, and there's a
Nothing to do with that.
definition
And if they
in
do,
there
they have to
on
notify
what,
the board.
right.
But it has nothing to do with this, with us.
What's come up within my peers, and I'm in different reviews, is what I thought the problem was, because I didn't understand it seemed like two different things, and it was, is when we go to peer review to discuss our transports and the ways that certain things went, some of us are not feeling safe discussing those things. There's a lot of new midwives coming in. And so there's this, I'm not so sure that I'm safe to actually discuss this case because maybe someone in this group will leave this group and discuss this with someone else or report me. And so what we have been talking about is what does a protected peer review look like for us? Where if one midwife has a situation with another midwife, is that something that's done in peer review? If one, or what? How is this protected?
I think
So it
as
seems
a
like-
midwife,
Sorry, go
in a
ahead.
situation like that, you have a HIPAA agreement that you sign when you participate in your peer review. And if there is discussion outside, that's a HIPAA violation, and that's reportable, the violation.
But do peer reviews currently do that? I mean, we don't bring up names or discuss, who or what is where.
I think the peer review I'm in, we signed
No.
a HIPAA agreement.
So,
Protected health
okay.
information. It's not up for discussion outside of care of that person.
Yeah, I think we've gotten way far from where we started.
Tuna fish.
Yeah. So, does anybody else have any questions about the peer review piece? Have we sort of No, we haven't answered them all yet.
Clean Joy, licensed midwife. So give us, who are in our communities having our peer reviews, are we now responsible for creating a document and being able to keep track of those midwives and then being able to report them to the board, or is that only an organization that is? Help us to understand in our own communities what we're responsible for doing.
You as an individual midwife you are not responsible for making this report. So the law defines what a peer review body is. It's not, just a group of midwives getting together to review cases. So there's a specific definition in the code under 805. And it says that for a professional body, I would say probably the chief executive officer or administrator would apply to CAM or CALM, is responsible for making the report. And the board has a form already developed for making the report.
Thank you.
And so then, if I'm understanding right, the professional peer review group that is under a professional organization would probably also be required to keep documents of the cases that were reviewed and the outcome of the review, whereas a group of midwives getting together to review cases is not, it doesn't fall under this statute. Am I correct?
It's very specific.
All right. Anybody else?
No, part of our implementation will probably be putting something on our website, so
Thank
to answer
God.
like FAQs or something like that. It's like they're needed.
Yeah. Anybody else? No. All right. We're good. All right. So we've finished with the update on midwifery legislation. The next agenda item 12, is my report on the licensed midwife annual report task force. And I think we've all been sitting here long enough that we could use a 5-minute break. So I'm gonna pull chair privilege and call a 5-minute break. We'll be back here at 3:18.
Can we go first to the restroom?
Yeah. All right. We have one more comment on the whole peer review issue, just for clarification.
So the legislation doesn't require midwives to participate in peer review. If they are part of an organization that does require peer review, then, and they meet the requirements of 805, that's when a report is necessary.
Thank you. Everybody got that now? You don't have to peer review, but if you do, and you do it with your organization, then you got to follow those rules.
The rules that the organization put forward.
And the rules of reporting according to the statute.
And it sounds like what the statute says is that if there was a disciplinary action. So if in a professional association's peer review, there was no disciplinary action, then they would not be required to.
There's nothing to report then.
That's right. For a professional society, it would, termination, denial are the key things. But there's a list that it's best that you look to the language itself. I'm not going to read it all.
Thank you.
Since it doesn't pertain to us, that's more than okay.
Well, it may pertain.
Read it.
So I don't want to say it doesn't. It may.
All right. Anybody else have anything else that they want to ask about peer review? Now's the time.
So I want to just remind everyone that the purpose of all of this was so that we could have a quality improvement program, so that if there are cases that do need to be reviewed by the professional association, especially when there are bad outcomes, that
There's a mechanism.
that there's a mechanism for being able to have it reviewed by peers. Because right now, someone has a bad outcome and they don't talk to their peers about it because their lawyers tell them, don't talk about it with anyone. And so there's no opportunity for any quality improvement.
Thank you. All right. We're moving on to agenda item 12, which is the long-awaited Licensed Midwife Annual Report Task Force meeting, which Diane and I worked with staff on this in August. I'm hoping that most people have reviewed the report because that will make this go much faster. Essentially, in March of this year, staff put together a 2-question option to be posed to licensed midwives when they filed their statistical report this year. And option 1 was to continue to collect data the way we've been collecting it in an accumulative way at the end of each calendar year. And option 2 was to completely start over and redefine the whole system and collect things in a prospective manner, so that when you would be collected more like the MANA statistics are collected. Midwives overwhelmingly chose option 1, which is to continue to do it the way we've been doing it. 135 out of 182 responses wanted to do it that way. So this report is designed around doing that and correcting some of the things in the data collection tool that we know don't really get the information we want. So that's what this report is. There are copies in the back of the room. Blue type is used to delineate added words, and strike through is used to delineate items we'll be removing. This report is very, very similar to the report that was done a year and a half ago in August. So there isn't a lot of change here. The first thing I'd like to do is ask the MAC members if, when they went through it, they had any suggestions or additions or comments, because we could start there. No.
I thought it looked really good, and I appreciate all the time you put into it.
Great, thank you. So one of the things that I thought of actually today that isn't in this report is that in section D, client services, we collect the total and number of people that a midwife saw, the number of clients who left for non-medical reasons, the number of clients who left for medical reasons, how many did that leave. It seems to me that if we want to understand more concretely whether the number of hospital forms adds up to the number of transferred clients, we probably should ask that question here, which would be to add a question, total number of clients that were in your care that you transferred to a hospital during care, and they remained in the hospital and no longer under your care. That way we could match that number with the number of transfers. So that was pretty much my only add to this. Some of the key takeaways from this are that we created an entire new section to record deaths in, because a big thing over the years has been that there were too many places to say that somebody had died and they didn't add up. And they didn't add up because we reported them in this section, and then we had to report them again over here in outcomes after transfer. And sometimes those numbers did not mesh. And so we thought that because the number of deaths that midwives deal with are so few, that we could collect that data in an individual section. We could get more information about individual deaths than we can get doing it in a broader way. And so we've recommended that take place. We also recommended that the county be removed from published reports, so that that information would still be collected, but it wouldn't be public knowledge unless somebody specifically asked for it in the Freedom of Information Act. And the reason for that recommendation is that because we're such a small midwifery community, it makes it too easy to identify a client or a particular midwife if we publish the county. The other thing that we wanted to do was to add information to bring us current with 1308 in terms of things like, did you deliver a baby and the woman was under 37 weeks or over 42 weeks, or did she have twins, or was it a breech? Even though some of those things are outside of what we are allowed to do, there is a recognition that once in a while it's going to happen just by the nature of what we do, that we're going to show up and somebody is going to be very quickly having a baby and it's not safe to transfer them anywhere. So those things were added in. So when you see them and you think, well, we're not supposed to be doing that, we still want the data on it, on whether it's happening and how often it's happening. We created a completely new section for VBACs. Currently, the only data that's collected around VBACs was how many successful VBACs at home were there. Well, that doesn't tell us anything about how many were attempted, how many weren't successful, and what were the outcomes individually from, parsed out from other transfers of care that we've done. So there's a whole new section added to collect the data specifically on VBACs. Let's see if there's anything else I want to highlight here. There are some changes in directions. There are some new definitions. And I think everything is pretty well laid out here. What I'd like to know is if anybody has anything to add or has significant concerns about anything we've put in that they think ought not to be there.
Kelly Olmsted, licensed midwife. Back to 42 weeks. I would love to see something on, it's the bottom of page 3, where you have the number of live births after 42 and 07. Delineate between out-of-hospital birth and after transfer in hospital. It's completely missing the third category of left my care and didn't go to the hospital. And I think there's a not insignificant number of women. I've had 2 this year, one who left my care and delivered with an unlicensed midwife, and another one who would have left my care at 42 weeks and delivered with a unlicensed random birth assistant who just knew how to do fetal heart tones. So I think those are important things for us to capture. I don't get the far out, people. I get professional women who are choosing other than going to the hospital at 42 and 07. And I think we need to capture that data, especially if we have a chance to change that law in the future.
That's a great idea.
So let me ask the question, given what I just heard about unlicensed practice of midwifery. Those people get reported somewhere? Should they be reported somewhere? Are we doing the public a disservice by not supplying that information somewhere? I'm not sure where that information should go. If they're nurses or if they're public people? If they're non-professionals, I don't know.
I don't know who they transferred to. They left my care at 41 and 6 at the end of the day. And I only know through the grapevine that they went to a community 3 hours away where there was an unlicensed midwife willing to take them sight unseen in labor. So I don't know who that is.
It just seems that for public protection, if it's an issue of public protection, that knowing about something
I think the
is-
bigger issue is allowing women autonomy of care to be able to keep their midwife at 42 plus weeks with informed consent, because women want that anyway, and if they can't, and the safest way for them to get that is with their licensed midwife who knows them and can continue care with them, rather than somebody who doesn't carry Pitocin, somebody who doesn't have the things that they need to provide safe care.
Okay, I just went for future discussion. I think that just we need to
Yeah.
figure out what to do.
Well, I think that Ms. Yaroslavsky is correct that we don't serve the public by not knowing who these unlicensed practitioners are. But I think Ms. Olmsted is also correct in that if we don't collect the data on how many women are leaving an LM's care and then birthing without an appropriate care provider that is licensed by the state, if we don't have those numbers, we don't have a prayer of ever changing the law, the legislation. Well, it's in statute, so it's a statutory change that would have to happen in order.
I'm saying with the LMR, it's not there to add it. It's
No, we can add collecting the data,
Right, so
absolutely.
that's what I'm
Yeah.
saying.
Anybody else have any?
Do we have to make a motion to do that, or can we just?
No, because we're going to do
Okay.
it all at once.
Great.
Faith Gibson again. I wanted to give just a little bit of background information, which is because I'm the culprit in some of our problems with the LMAR. Is some gazillion years ago, 10, 15, something like that, I overheard a conversation between a medical board member and a lobbyist in which he was railing about how come the medical board didn't know about what midwives were doing, and the staff member said, well, we don't have any information on what midwives do. I mean, we license them, but we don't have any information about what happens afterwards. And I thought, when I heard that, I thought, well, they should. We really, to be accountable, we should. So I went to Senator Figueroa's office at that time, and I worked with Vince Marchant. I don't know if you remember him with the B&P committee. Anyway, I came up with the original stuff that went into the law, but I had no background in any statistical analysis, and so it was terribly deficient. And all I can say is that whoever did this should get a gold medal, because this does exactly what we've been stuck all these years, is that we kind of got half of a loaf. And we didn't get the kind of information that could actually do what I thought was necessary, which is to help us improve our educational process. If there are problems that we can tell from the problem, what we need to do about it is to change or increase education. And also to establish that what we're doing is appropriate, that both of those things, we need more information to do that. I have only one very tiny little thing to say about the list, which you talked about a minute ago, having to do with those things that are currently in 1308 are verboten, so to speak, which is the breaches and the twins and the multiples and the like, which is, it talks about whether or not it's in or out of the hospital, but it doesn't catch the information about whether or not the midwife, whether it was a precipitous situation. So whether or not the sentence that leads into it acknowledges that these are typically precipitous births that are occurring out of the hospital, or you state it as a part of the information, you add that on, kind of what we were talking about a minute ago. I think that would be very useful, because otherwise it kind of looks like midwives are kind of giving the finger to, like we're just going to do what we want anyway, which is not the case. I also want to say that I personally know of 2 post-dates mothers who fired I was not their midwife, but the midwives walked out at midnight, said, I'm sorry, I can't provide care to you anymore. And in both of those instances, a local labor doula person wound up delivering their baby. I think having somebody there that knows something is better than having nobody. I'm not particularly a fan of trying to, report unlicensed midwives or lay midwives under those circumstances, because mothers and babies are always safer when there is somebody there who knows at least something as opposed to nothing. And I can see from statistics about the reports of unlicensed midwifery, you can just go through, that's one of the things, pieces of data we now collect, is that as we've had more and more licensed midwives, the number of unlicensed lay midwives that get reported or get into trouble has gone way down to almost nothing. There's like only 1 or 2 cases a year that are being reported. So I think that also applies to the VBAC issue and to the 42-week issue, that by making it impossible for the trained and licensed professional midwives to provide care, we are recreating lay midwifery or increasing the number of unattended births. And unattended births are dangerous. 1 out of 57 is the number for maternal mortality, and 1 out of 23 or something like that for neonatal mortality for unattended births. So anyway, that's my thing for today.
Thank you for
listening.
that. So based on what Faith is saying, and what the previous speaker said, I think that breech deliveries, twins, and multiple births other than twins, on page 4, those should also get the ad delivered outside of licensed care, and then you could also include a reason that the midwife delivered that baby is because it was precipitous. So as like a separate checkbox. The other thing I wanted to say about this is how this is going to be formatted into the questionnaire that you will work with online is going to be decided by staff, and then there'll be like a mock of it that will come back to the MAC, and we can go over it and make adjustments where they're needed to make sure that we're still capturing the data we want to capture in the way that they've designed the form.
Can I raise a concern about reporting things like delivered without care or with unlicensed individual, that the other data elements are within the midwife's direct knowledge. And with these suggested ones, I think you're hearing it, secondhand, third hand.
Fake news.
So I do have some concerns about that, because I mean, if you know it's being done by an unlicensed person, that to be the case, I think it's going to raise concerns. But
is there a way to collect the data? So we want that information just like we want cause of death and outcome in other places, and sometimes that is also gleaned maybe from the client herself, or it may not be as concrete of data as we'd like to have. Like, it may not be that the midwife looked at the discharge summary from the hospital and so she knows for sure what the outcome is. It's much more likely that the midwife knows the outcome because she talked to the client when the client came back postpartum. But I don't think we have, it seems like there needs to be some way to have this tally, and I'm wondering if you have a better suggestion for how to get it.
not right at this moment.
What about having some kind of a sentence or two that says, did you discuss with the mother after she had her babies, where she had her babies? If so, what did she say? Something like that. That way you couldn't just hear it through the grapevine that she had her baby with so-and-so down the street. You would have had to talk to her and got the information from the actual client.
I think that's a different format than the other data elements that are being sought.
Definitely.
Well, it could be a yes or no. Did you speak to the client after she had her baby, and did she disclose to you whether she'd gone to a hospital or she'd had her baby in another setting. If the answer to that is yes, then you can have it,
What, maybe it could say,
seems like it's a
have you had any clients who left your care at 42 weeks or more? Then it doesn't matter who delivered. The point is they left your care at 42 weeks.
Well, no, that we can get. We're trying to figure out how to get where they had their baby.
Because
Well,
I think
you're just trying to get the space in between, delineate between out of hospital births, which is you completed that birth out of hospital at 42 plus whatever.
Right.
And after transfer in hospital, there's a third space, which is neither of those. You could have or neither. And it doesn't matter whether they delivered with an unlicensed midwife or they delivered with a labor and delivery nurse or whether they delivered by themselves. Those aren't the issues. The issue is what happens. The assumption with this law has always been that at 42 and 0, midwives are going to say, we have to transfer in, and the client's going to say, great, I'll get in the car and go. And the reality is that doesn't happen. I mean, it does happen, but it also doesn't happen. And that's what we need to capture is those women who are choosing to exercise autonomy over their health care and not make the decision that this law has decided was their only option. That's all we need to capture. We don't need to capture what specifically they did other than that they left care and did not go to the hospital.
Due to statute requirements.
Would that be a way to fix that?
They could also have gone to a CNM who doesn't have that in their licensing law. They have other problems with their licensing law, but they don't have that hard 42-week deadline. So they could very well go and deliver with a CNM or whatever.
Or we could just say, did she deliver out of hospital? Often these women come back to us for postpartum care. Most midwives who have to stop care at that point are devastated. Not as much as the woman herself, especially in places where there's no options, but it's horrible. And now that we've taken away women's right to choose their own care, we need to have some way of finding out what they actually did so that possibly there can be future change in our law. And the other thing that many of us have ourselves given birth at home after 42 weeks, or how many women in this room right now practiced midwifery before 1993 or 1996 when we actually got licenses. That's all I need to say.
Thank you. So if we just had neither, would that solve the problem without creating other problems? Or something that didn't specifically say she delivered out of hospital with somebody that wasn't licensed? Or, without having to qualify how she delivered, we just would know that she didn't deliver with this midwife and she didn't deliver in the hospital.
I think that's what we can legitimately say. We can say, did not deliver with this midwife and refused transfer to another provider.
We're going to get this much information about 42 weeks. I'd like to know if they gave birth unattended.
I also think that if we're going to be asking or saying that they left care, it's important to know why. If they're leaving care at 42 weeks, was there an issue with the midwife? Or did they just say, I want to exercise autonomy? I think that's really important. No, I understand that. But there are other situations where someone may transfer care. And just saying that they transferred care doesn't necessarily, to other people outside of this room, explain why, right? They don't understand that women don't have an option. Pregnant people don't have an option. So I think that getting that specific is useful.
But to know that they
wanted to have a licensed midwife at their side and couldn't, I think that's really relevant.
Doesn't the LMAR already have a place for people who leave care for either medical or other reasons? In other words, it would take it out of the 42-week issue and back into the midwife. The mother didn't want to, whatever.
I think this is a different issue because it's not an issue of somebody just left care for whatever reason. It's an issue of the midwife said, I can't care for you any longer because you're 42 weeks tomorrow. And to capture the data on what actually happened to that woman, I think is really important in the 42 week spot. I don't know whether it's just as important in the breech and twin spot, because those women are generally there's going to be a decision made about them quite a bit in advance of, them being term
So where do you
for the
wanna-
most
where do you
part.
wanna put where would you want to put the notation that a woman had to leave care after 42 weeks, or how did you leave care because the 42 weeks? Where would you think it'd be
I would
appropriate?
put in, I would
Page three?
add on page 3,
Yeah, okay.
I would just add that I think like Ms. Olmsted was saying, she delivered out of hospital with this midwife. She delivered after transfer of care in the hospital, or neither. Because that doesn't, then the midwife probably is going to know those two things. Certainly she'll know if the woman delivered with her, but you should probably also know whether the woman accepted her transfer to a hospital. She may not have. And so at that point, then the midwife probably for most cases is going to know that she didn't go to the hospital, that wasn't her choice.
So are you looking for a vote on this today?
Yeah, I'm looking to move this forward today.
So are you okay with moving it forward with the inclusion of the 42 week issue? Or is there something else you want to add to this? What we're looking
Well,
at?
I wanted to be sure that people had voiced all concerns on any of it
Okay.
before we moved it to a vote.
So my concern is it needs to be included in breech and twins as well. You have to put that in there because there will be mothers who are not going to go to the hospital and are going to have their babies at home breech.
Yeah.
Or with their twins. So it has to be included in that too. Yeah. Really, yeah.
You have it here. You have G. You have on G on page 4.
Yeah, but that's the
Change the
antepartum transfer.
Can you get rid of that?
No,
you can't.
that's a
Okay.
heading. And we transferred because they were more than 42 weeks or less than 37 weeks, but that doesn't address the didn't transfer because
refused
they didn't want to
transfer?
go. Yeah. We don't.
We just put that in there?
What if you put antepartum transfer / refused inability to continue practice? If you put some.
What about the ones that leave but then end up in the hospital and deliver at the hospital?
The Section E is
The better
like a
place?
conglomerate of all the data, and I think that's probably the most appropriate place to put
So if
it.
you want it in E, put it in E. It's fine with it. It's fine with everyone.
Yeah.
We'll put it in E, correct?
Yeah,
Good. Let's put it in.
and include it with breech twins on multiples.
Okay, so we're going to do it in section on page 3,
3 and 4, yeah.
3 and 4,
And
section E.
and
Okay.
to add for all of those instances, a box that would say, did this woman deliver precipitously or something, where a midwife could note that, yeah, she went to the breech delivery. She was going to take the woman to the hospital, but she delivered really quickly and she didn't have an opportunity to do that. Ms. Perez?
Yeah, Laura Bettis, licensed midwife. So this is one that has bugged me. It's not very significant, but I think it's important to get clarification on it. The first one on line 13.
Which
when
page?
I'm sorry, bottom of page 2, section D. For birth-related care, I know I've asked about this before, and I think I've gotten different answers, so I just want a clarification. So if I have a mama that births in December, the previous year of the LMAR reporting cycle, and then I give her postpartum care in January, am I to include her or not in the numbers is the question.
Yeah, you include everybody that delivered before midnight on December 31st. And the reason you don't have to finish submitting everything until the end of March is so you can capture that 6-week data.
So mamas that haven't birthed in that year are still included in this
Yeah,
data
so if
here.
for your 2018 statistics, you include everybody that delivered before midnight, December 31st this year, 2017.
Right, but I'm talking in 28. Sorry, say that again. My mind's
So
blank.
everybody that delivered this year,
Yes.
up until and including midnight on December 31st, 2017
Yes.
goes into your 2018 report.
Correct. Because I was told differently by a former member of the MAC differently. So I think that
Yeah.
should be clarified in that area. That's we are including
Think-
everybody there. In case.
There's a definition regarding birth-related care. There's another, somewhere in here, there is a definition for that. And I don't remember where it is exactly. For birth-related care, but then birth-related care is a definition that excludes well woman outside of the childbearing year
Right.
for obvious reasons, because none of the rest of this applies to them. No, somewhere. Maybe it's, let's see, total number of clients. Well, I know it's here. Line 15. Total number of clients served whose births were still pending on the first day of the new year. And the reason that was changed is because if they're still pending on the last day, on December 31st, you still have to include them because it's part of the 2017 statistics. So if you have somebody who's still pregnant at 12:01 a.m. on January 1st, they go next year.
Right.
They don't go this year.
You don't get the tax deduction.
Right.
Right. Put it that way.
That's a good point,
And soon
Barbara.
there will be no more tax deductions anyway. so
That's
don't
right.
worry.
That's right.
Yeah, and we purposely designed it so that data wasn't having to be submitted until the end of March so that you could get that 6-week
Great,
postpartum
great.
data on
Thank
those
you.
people. Thank you.
You have another person.
Yes, Rachel.
Rachel Keene, licensed midwife. Sorry, back to the last thing about people who leave our care to give birth in some other way, alone or with non-licensed providers. Is there a reason not to include that on page 2, section D, client services? Is there a reason not to have, say a line after clients who left care for non-medical reasons of clients who left care due to limitations of the midwife scope of practice and did not birth in the hospital?
We could do it there. It seemed more practical to do it in section E where we were dealing with outcomes. It's also maybe also needs to be
The other thing is that
added
we wouldn't
to.
necessarily know the outcome in some of those cases, and so that's one reason why it seemed to me possibly more appropriate to put it there. Those people are in many cases lost to care.
Right, but that could also be an option that they outcome unknown. Yeah, and probably should be.
Carrie, once we approve this, are we going to see another draft before we go and finish it
No.
up?
No,
Be a mock-up, right?
no.
I would suggest
This is
that-
it.
I would suggest that we vote to accept the revisions as stated with the additional additions as have been recommended to the chair. Because this needs to move forward already, I think.
Yeah, I mean, we've been working on this for what, 3 years, 4 years?
not
I've
developed.
lost track.
I'm
And
moving.
no, it's not coming back again. It's
Okay.
going
You've
forward.
heard what I've done?
Yeah.
So I've made a motion.
You've made a motion.
Second.
We have a
Any
second.
conversation on the
Need to
motion?
make a suggestion after April says something.
Oh, no, I was just gonna.
Okay. I think that you make a motion to accept the proposed changes recommended by the Elmar Task Force with the additional recommendations discussed today, and you delegate to the task force working with staff to add the suggested language into the Elmar form. And that way the task force can review and with staff work out the bugs.
That's
in
my
the
motion right
language.
there. That's it.
Got
Okay?
it.
And that's your second.
I'll
correct?
second that.
Okay, now you have some public comment.
All right. Anybody else? Does anyone else want to say anything more about this? Because the procedure, as I understand it, is if we adopt this today, then it goes to the board, the full board in January.
Right.
And then staff can begin to work on it. right?
Or you're finished with it?
Well, no, because I'm gonna have to work with
Finish-
staff to
you're
finish
finished
it.
here
Yeah.
now, is what I'm saying.
All right. No more.
Staff, after the board approves it, staff will start working on developing the database with
Right.
the information.
Got it. Any other comments from the MAC? All right. Will you call the roll, please?
Dr. Adams,
Yes.
Ms. Dugan,
Approve.
Ms. Holzer,
Yes.
Ms. Perez,
Yes.
Ms. Yaroslavsky,
Adopt.
Ms. Sparabon. I
Yes.
think I should go to Barbara.
Oh man.
No, you should just read the name. It's very phonetic. It's really not so tough.
I don't know why.
I
Okay.
don't know. We'll go over. We'll have a
It looks
tutorial.
tough.
We'll have a
Yes,
tutorial.
it's intimidating.
It's like Sparavon. Sparavon also looks tough.
Motion carries.
Continue.
All right. All right. So we're through that. Number 13 is the program update. Ms. Almeida, please.
Okay, so the first thing I'd like to do is introduce a couple of people that are new to the medical board. We have Christine Lawley,
Is your
Deputy
mic on?
Director. Yeah,
Okay.
I'm not loud enough.
You just have to speak into the mic versus turning your head to look at Ms.
Sure,
Lawley.
sorry.
That's better.
Christine Lawley, Deputy Director. Also Monique Murray, right here. She is the new manager of in licensing program who now will take over Natalie Lowe's position.
Great.
So you'll see her a lot. The next update is we have 2 MAC members appointments that expire in June 30th, 2018. So we will be advertising at the beginning of January and bringing all applicants to the MAC in March for you guys to review and make a decision on who you'd like the board to review and make final approval. So that will come out soon. And then the next is to just go through the licensing program statistics. So if you can turn to tab 13, page 66. This first quarter in fiscal year 17-18, we received 8 applications. We issued 10 new licenses. We only have 1 pending application at this time, and we are actually up to a total of 395 renewed and current licensed midwives. Pretty consistent with last year's statistics. Does anybody have any questions about those statistics? Okay. I will move on to the out-of-hospital delivery reporting forms, which we have already spoke a lot about. We've received a total of 46, 45 for licensed midwives and 1 unlicensed unknown. Enforcement statistics for licensed midwives, we only received 2 complaints. We had no referrals to the Attorney General's office or criminal action. Still, 3 were referred to investigation. And as far as unlicensed midwives, we also received 2 complaints in the last quarter. You can also see, I apologize, there was a mistake. There was a number 9 in in quarter 2. That was just a mistake. I think my eyes thought it was a 0. So do we have any questions about statistics or?
I have a question.
Sure.
So the total number of investigations currently open can include ones that came from other fiscal years, correct?
That's correct.
Thank you.
All right, easy enough.
That's it.
Any questions, comments? All right. All right, so we need to talk about future MAC meeting dates, which is in tab 14. I would like to not meet on March 8th since that's my birthday.
March 15th is the BRN meeting. August 9th is my birthday.
Well, I'll do it on my birthday if you'll do it on your birthday.
No, I don't know. Can't we find another date in March or no?
Is there not, is March negotiable at all? When's Passover?
I'm gonna look right now.
I have it in my head. Right, because it's earlier this year than it usually is. This is in April, middle of April, and usually it's at the end or the first week in May.
But I'm looking for it specifically for holidays. That doesn't-
What if we did it the last Thursday in February? Does that give us enough time to notice the open positions or not?
Well, we will notice it in January. We're gonna give 30 days.
For people to get,
We could make that work.
Or March 1st,
How about
right?
picking the 7th?
oh,
How about the 7th instead of Thursday? Do Wednesday.
March 1st?
oh yeah, we could, what about March 1st? Can we do March 1st?
Works for me.
Okay. Does that work for everybody else sitting here?
I'm looking. Yeah, I think that works for me.
Dr. Adams, does that work for you? Yeah, okay, we're good. All right, so March 1st. And then the 9th is your birthday. So I guess
We're
we're,
to announce it.
hey, it's better than the alternative. Having a birthday is better than the alternative.
My daughter's the 16th. Is okay.
Oh,
16th is fine.
16th? Is everybody else okay with August 16th?
Mm-hmm.
Yeah, okay. And then
The
December
6th.
6th or 13th, do you know when Hanukkah is next year?
It's just more that the later into December you get, the more nobody wants to go to. It's Christmas.
Hanukkah's the 3rd through the 10th.
Hanukkah's not a religious holiday. It's more. My concern is the schedule of December. The later into the month you get. To be honest with you, that's all I'm.
Okay.
And my
So if-
daughter's birthday is the 12th, so the 13th would be tough.
Okay, so is this, the 6th works for you even though Hanukkah's the 3rd to the 10th?
Yeah, it's fine. Hanukkah, trust me, is just not a religious holiday.
I think there's Christmas anymore. So
Merry Christmas, Corner.
December 6th.
The
That
government's no longer shutting down if anyone's interested. We've got 2 weeks grace on that.
Oh, did we?
Yeah. So
Was
we're doing
there
the
ever
6th.
any
Wait,
doubt?
we're doing
So
the
we're
6th.
March 1st, August 16th, December 6th.
Is that okay with everybody?
So I need a motion to adopt
So
those dates.
moved.
Second.
What was the second date? 16th.
Okay. Dr. Adams?
Yes.
Ms. Dugan?
Yes.
Ms. Holzer?
Yes.
Ms. Perez?
Yes.
Ms. Yaroslawski?
Yes, you did much better this week.
Ms. Farabon?
Yes.
We gotta practice that.
Okay.
Thank you.
All right.
Now I can go to the
Think
airport.
about it.
Okay, no, there's one more thing. Agenda items for the next Midwifery Advisory Council meeting. So currently, there's an update from the chair, update on AB 1308, update on the Midwifery Task Force, update on the hospital transfer form, update on midwifery legislation, update on the Elmar Task Force, and update on the midwifery program.
Update on the interested parties that the DCA is going to hold. Not DCA, Senate BNP.
That'll be covered in 1308, wouldn't it? Update on AB 1308, would it be covered in that, those regulations, or do we need a special item?
Update on the interested parties meeting. That assumes they're going to have an interested parties meeting.
Well, they
so
might
we need
not
an
have
update.
one by then.
Well, but if it's on the agenda, maybe they'll have one.
I think it's a separate agenda item. There's going to be overlapping issues.
Mm-hmm.
I think the update on the regulations doesn't need to be on
Yeah, I
the
was
next
thinking
agenda.
that too.
Okay.
Um,
Then don't put it. I just was
So-
trying to give you some.
So we probably also don't need an update on the midwifery task force either, right? If we have the update on the interested parties meetings that the Senate's holding? Do we need both of those?
I would recommend keeping that one just
Okay.
in case.
Okay. All right.
Is that also, that's also when there, is that the one where we're going to have new members?
No, we need to add, oh yeah, we need to add that. Election of new members. We need to elect a new chair because March will be my last meeting. I would also like to have a discussion again about term limits for MAC members. And Miss Joy has started a new mentoring program for new midwives, and I would really like it if she would give us a report on what that looks like and how it's progressing, unless somebody has a problem with that. Anybody else have something to add here? No? No? All right. So what we've deleted update on AB 1308. We've added an update on the interested party meetings that the Senate's going to hold. We've added the election of new members. We've added the election of a new chair for the MAC and a new vice chair, actually, because we haven't had that in a while. And a discussion about term limits for the MAC and the mentoring program that Ms. Joy is working on. All right. Do I need a motion for that?
No, you decide what's on the agenda.
Okay, that's it.
I would move to adjourn. How's that?
Is there any public comment on this? No, seeing none? All right. This meeting is hereby adjourned. Thank you all for being here.
Carrie.